All right, let me start off with an item that builds on what we talked about last class and also in the news a little bit. We've talked a little bit about the Aral Sea and the Amu Darya and Syr Darya basin, and I just want to highlight a little dispute going on. This is the basin of the Aral Sea, so you have the two big rivers, the Syr Darya on the northern part, and the Amu Darya is the bigger river on the southern part. And right around, if you can see my arrow right here, this is a tributary called the Vaksh River. And there is a plan to build a very large dam on here, and this is inside of Tajikistan. And you can see they actually started construction on this dam in 1976, but they have halted the construction because they didn't have the funding, and then they had a contract with the Russians, and then the Russians wouldn't do it, and there's been some other challenges in terms of coming up with this particular or construction of this dam. If it is actually constructed or finished, it'll be the world's tallest dam, standing at around 355 meters. The estimates right now are around 2 to 5 billion, and some people say that that's really under what what they think it really is the true construction cost of this region, or to construct a dam in this region. Just a few specs about the dam. One of the biggest justification for this dam is the electricity that would be produced from this dam. It should be able to provide enough electricity for the entire country of Tajikistan, which is really energy starved, as well as to sell electricity to some of the neighboring countries, Afghanistan, maybe Uzbekistan, Kyrgyzstan, those nations. So here's where we have the problem. So Tajikistan is arguing that they have chronic electricity shortages, low economic standards because they don't have much of an industry. They don't export any kind of finished products. They don't have very much in terms of their economy going on. So this would be a huge boom to their economy, especially if they can sell electricity to other countries in the region, which also definitely need that energy. They've actually invited Uzbekistan, which has been objecting to this dam project, and Uzbekistan has rejected collaborating on it. A World Bank study last year said that the dangers from the Rogan Dam were rather small and easily mitigated. And Uzbekistan doesn't agree. There have been no seismic studies in the region, and they're very concerned about earthquakes. And there have been some pretty sizable earthquakes. If you remember, Afghanistan just got hit with an earthquake. There's been earthquakes in Iran. There's been earthquakes in various parts of the region here, and so they're very concerned what would happen if this massive dam, imagine a dam that's 1,100 feet tall, ruptures, and that wall of water just cascades downstream. And so they're very concerned about those issues, and Uzbekistan is downstream. They're also concerned about the water flow that is going into the Aral Sea. We talked about that the Aral Sea is almost completely dried up, and they're very concerned about water for their agriculture. And they're concerned about it during the time that they're going to fill the dam, which may take a couple of years, as well as during the operations when they decide to increase or decrease electricity production and thereby increase or decrease water flow downstream. So this is your classic upstream-downstream debate. And the latest is from, I think, about a week ago, where I don't think you really have to read between the lines, but this is what the president of Uzbekistan said, that this could lead to a water war in the region. Now, whether this means that they would start the war or somebody else would start the war, you can read that into that on your own. But this is the, as I said, classic situation of upstream downstream disputes, countries not quite willing to cooperate and negotiate. I think I sent around the one short article about trying to share benefits on this particular river, and this is a dispute that is ongoing right now. It has been in the news for the last couple of years, and now it seems to be heating up again. So we'll see what happens there. Anybody have any other good news items?
We have good news down in Galveston that we didn't get washed away yesterday and the day before.
All right. We got some rain here, but it wasn't too bad. But nobody has any news about any international water issues going on? Global water issues? Just keep watching the news. It really is always there. As I said, at least on the Twitter feed I have, there's got to be at least 6 or 8 or 10 stories going on every day. Something happening around the world. It's really a significant issue, and I think it's something that's growing. You'll see it continuing to be in the news. So,
Gabriel, I have a funny news for you related to Patricia, the hurricane in Mexico. That everybody was expecting, destruction and death and all that stuff. And, we have a lot of experience with these kind of events. And nothing bad happened. Nobody died, apparently, that we could regret. But then the society was expecting that. So now there's people are reacting like, why did they say it was so bad if nobody died? So we were expecting deaths, and because we didn't get enough, I guess, destruction or deaths, now the society is saying, oh, the government lied about it,
Right.
So because nothing happened. Anyway, I just thought of sharing that with you guys.
It's something you see in a lot of places around the world where governments either do just the right amount of preparation and nothing happens, or go beyond the right, the right amount, nothing major happens, and then they get criticized for being overprotective.
It's better than the other option, which is Katrina.
Which, exactly, it's better to be overprotective than underprotective. Katrina is a great example. Yeah. All right, if there's nothing else, let me go to a different set of slides. Start the conversation. Let's see, where is it? All right. About 15 years ago, there was a very serious cyanide spill on the Tisa River in Central Europe. The Tisa River is a tributary to the Danube River. It starts in Romania and then flows into Hungary and joins the Danube there. The background to this story, cyanide is used in gold mining, and there's a pretty major operation in Romania in this facility called Baie Mare. And what they do is they take they mine the gold, and the gold's stuck inside of rocks and sand and dirt, and to get the gold to come out of all the other stuff that it's mixed with and other minerals and so on, cyanide is a really good chemical that will break that gold apart and literally pull it right out of and separate it from all the other components. The problem is that cyanide also helps to break out some of the other items like heavy metals, and so you end up with a slurry or sludge material. And after you're able to extract the gold, you're left with this material that you then have to do something with, which now has a lot of heavy metals and the cyanide and some other pretty nasty stuff. The typical way to treat this is to put it into ponds, retention ponds, like you see at the bottom right there. These ponds tend to be lined because you don't want that stuff, leaking into the ground, into the groundwater. And you either let it settle, so the metals settle to the bottom, and then you evaporate the water, and then you take that final sludge and you bury it, or there's some other procedures to try to clean the water and extract some of these really toxic and hazardous material out of the water before you return the water back into rivers. So in 2000, in January, there was a massive rainfall, snowfall event in this region where they have all these retention ponds, and the ponds just flooded over. And you can see the break in the retention wall there, about 25-meter section of the wall broke down. Then if you look at the photo below, it just completely covered dozens and probably hundreds of acres with the water-tainted material. And 100,000 cubic meters of liquid and suspended waste contained tons and tons of cyanide and heavy metals just washed out into the countryside and then into the Tiza River. You can see here the star, that's Balimara, that's where the plant started, and the Tiza River flows from Romania and then into Hungary and eventually joins the Danube River. And in fact, they traced this, here's another map, they traced the flow of this pollution going all the way down the Danube and eventually into the Black Sea. And you've got on the right side the different dates from January 30th all the way to about the end of February. 25, 28 days later, it finally reached the Danube Delta, which is right on the Black Sea. The consequences of this spill, very significant contaminations of the rivers, both the Tiza and the Danube, massive fish kills, contaminations of public water supplies, all the way into all these countries, because the Danube at that point forms the border of a couple different countries as it makes a way towards the Black Sea. So really significant contamination. So that's the background. I want to show you now, where is it? Look at this obligation in the UN Watercourses Convention, Article 21, Prevention, Reduction, and Control of Pollution. Was there a violation of this rule in that example I just gave you? So if you read this, the first paragraph talks about the definition or interpretation of what pollution of international watercourse means. And then the second one starts creating obligations. You think there was a violation of this particular obligation?
Yeah, Section 3B would start. I mean, that's to me, that's where that establishing not only what would be necessary to maintain and contain that material, but also the point to non-point sources. And I think all we have to do is look within our own country. We just recently had an incident in Colorado where a mine discharged a very similar effluent into a major river. So, and of course the EPA is struggling now to figure out who's to blame, even though they were the instigator of it. But I think the precedent is set in 3A.
Well, I want to put 3A aside, or 3A and 3B and 3C aside right now, because I want to characterize the difference between the obligation in 2 versus the obligation in paragraph 3. Think about what happened. You had this company, this cyanide spill, or the water overflowed the bank, and then the water goes across borders. Is there a violation of Section 2 here, paragraph 2?
Says shall prevent,
Okay.
so he didn't prevent it.
They didn't prevent it. Who didn't prevent it?
The owner of the potentially,
Oh, the owner of the company.
possibly.
But remember, who's an actor under international law?
And then you can look at, whether the laws that, that allow that retainment pond to be created was sufficient to meet these requirements.
Well, remember, okay, now here's where you've got to draw a difference, a distinction between the domestic laws of a country, which might give the criteria of the construction material and the criteria for what's an adequate retention pond, versus the general obligation here, which is Watercourse state shall individually and where appropriate jointly prevent, reduce, and control the pollution of an international watercourse that may cause significant harm, et cetera, et cetera.
So I guess what I'm thinking is you have those specific provisions to help fulfill these requirements.
Okay. But do you need to have domestic law to comply with international law?
I think you do sometimes to show that isn't it one way of obligating oneself
Okay.
to the agreements or treaties that you make?
Okay, so that's what may be one way to show that you're in compliance. But if you have a cyanide flow that crosses the border across the river, who are we pointing a finger at here? We're not pointing it at the company, we're pointing it at the state. Because whether the state has that domestic law, it's not that it's irrelevant, but it's under international law, only the state actors are the actors. What happens inside of their country, that's up to them how they want to treat, whether they want to do it through an authoritarian system or a democratic system, statutory codes, however they want to do it. That's up to them. So the obligation here is an obligation to prevent, to reduce, and control the pollution. Now, whoever they want to point a finger to inside their country, that's up to them. That becomes a domestic issue. But as an international law issues, that becomes an international substantive law obligation. Last week we covered equitable and reasonable utilization, and we covered no significant harm. Think about this rule in relation to equitable, reasonable, and no significant harm. It's a violation to either you violate it or you don't. You caused harm, significant harm, or you didn't. You were equitable and reasonable or you weren't equitable and reasonable. You caused pollution or you didn't cause pollution that's transboundary. That's what we call substantive law. And this substantive law is typically actionable only after the fact, after you have a violation. Okay? How is that different from the obligations in paragraph 3? What does the obligation in paragraph 3 say, and how is it different from paragraph 2 or equitable, reasonable, or no significant harm?
So you said that part 2 is it can only be acted upon after something's already happened, after you've already violated it. So Part 3 looks at things that you can do before you actually violate the significant harm or the prevention or reduction and control of pollution. So it's saying you can set up joint water quality objectives, between countries or within your own country, or you can, ABC. Those are all things that you can do before the violation takes place.
Good. So these are all actions that you can take before a substantive violation happens. And Patrick was saying these are procedural obligations. These are the two main types of, when you talk about law, you usually have substantive law and procedural law. And this is maybe a little bit crude, but this is the main distinction. Substantive law is what you must do, and if you don't do, you have violated that law, and therefore you must provide damages because you've hurt somebody in some way. Whereas procedural obligations, if you fail them, what is the remedy for procedural violations? Well, you must comply. That's the big difference is the remedy. Remedy for a substantive violation is typically damages of some sort or reparation. You've caused somebody harm. So there's 3 examples of no significant harm. Well, if you cause significant harm, you've got to pay reparations or damages. Equitable and reasonable, same thing. You've caused them some kind of injury. Same thing with the transboundary water pollution. Whereas procedural, again, if you fail to comply with the procedural obligation, the typical remedy is compliance. Now, if you've caused harm because you failed to abide by the procedural requirements, yes, you might have some kind of damages or some kind of reparations. But typically, the obligation is to abide by the procedure. Why is this important? Well, I think the comments that were just made about preventative action are really significant. And I want to go over some of these procedural legal obligations that you find in the Watercourse Convention and under international law. So one of them is, as you saw in this particular article, about cooperating over pollution, preventing pollution, and so on. What other procedural obligations would you identify that would help prevent significant harm, failure to abide by equitable and reasonable utilization, and so on? Yeah.
There are several, which is to cooperate.
Right.
To provide notice of planned measures, to do consultation, which includes the environmental impact assessment and the sharing of the data. Those are the ones I remember.
Right, sharing data, information. Right. I mean, those are the main ones, and you might be able to come up with some others. For example, creation of a joint commission. Might be another procedural obligation, or at least a recommended course of action. And there's a couple of procedurals. And what I'm going to suggest to you, and this is where there's some disagreement over, but I'm going to suggest that these procedural obligations may be more important and more significant in an international watercourse, at least under today's politics and the situation we have globally, may be more important than the substantive obligation. You can have a no significant harm rule and an equitable and reasonable use rule and a no pollution rule and so on, but once you have a violation, it's already too late. You have you have harm created. And aren't we really trying to manage these rivers in a way that we cooperate and we prevent harm and we maintain enough water for environmental and human uses and so on? Whether it's for the hydroelectric production upstream, but also for the cotton production downstream, that's what we're trying to do. And to get to that state or that stage, it's very hard to do so when you're trying to argue whose rights are violated or versus who has which water rights. So what I'm going to suggest is these procedural obligations may be more significant to have in an agreement or in any country that's negotiating with its neighbors in terms of trying to come up with, what are the rules and obligations as between us, U.S., Mexico, any of the countries on the Nile, and so on. So let's start off with what these obligations mean. Here's Article 8, obligation to cooperate. What does it mean in practical terms?
Sharing data.
What's that?
Sharing research data.
Sharing data? Maybe. We actually have another procedural obligation that's specific to data. So let's focus just on the concept of cooperation. What would you suggest that entails?
Prior notification.
Well, again, we have a separate provision on, actually a series of provisions on prior notification. How do you cooperate? Or what does it mean to cooperate, I should say? Not the mechanics of cooperation, but what does it mean to cooperate?
Transparency?
Transparency.
What? I don't know.
What's that?
I said, I don't know what you're being transparent of. I mean, obviously you can't give them everything.
Well, transparent in terms of what?
Data, like she said.
Okay, information. What else? How about you're sitting at the table and you're negotiating? And if we're talking about transparent negotiation, what are we really suggesting?
You're negotiating in good faith, maybe?
Good faith. So you're not there with subterfuge. You're not there with ulterior motives. You're not there negotiating as a front while your national construction company is starting to build the dam upstream, right?
Oh. How is that going to work in the Middle East then?
How's it going to work anywhere? But we seem to be doing it with U.S. and Canada, U.S. and Mexico, Europe, and many other parts of the world. So yeah, there's some places like Central Asia, the Middle East, where we haven't quite gotten the good faith part worked out. But the notion of cooperation is a procedural matter. When you sit at the table, you should be there in good faith. Can you control that? Well, I think that's going to be hard.
I mean, do you think that the idea of cooperation can be reconciled with water security, especially as like drought and climate change and stuff like that?
What do you mean by water security?
Each individual country wanting and negotiating the best possible outcome for themselves.
All right, so the best possible outcome. What if there's not enough water for the best possible outcome and everybody knows that?
Puts a lot of faith in people being reasonable and having good faith at the negotiating table, I guess.
Okay. So that's your basic notion of a procedural obligation to sit at the negotiation table in good faith and negotiate with transparency to the extent that your country can be transparent about secret information and secret instructions that your leaders have given the negotiators and so on. But that becomes a procedural obligation. Because, again, if there's a violation here, the remedy is, well, next time you come to the negotiation table, come in good faith. Don't come and lie. Right? If you have other water resources available, don't come to the negotiation table and say, no, we don't. Those are contaminated. And this is something that's happened in various negotiations amongst countries. But there does seem to be a very strong trend in the Americas, and in Europe of good faith negotiation, cooperation, collaboration, and even we're starting to see it in Africa and some other nations. How would you review somebody's compliance? And this is really a legal question. How do you review somebody's compliance with cooperation and good faith effort, good faith negotiations? What's your standard of review? This is a pretty common standard we use in the law. It has a very vague definition, but you heard due diligence. What does that mean?
The amount of information that's been shared.
What do you mean by the amount of information that's been shared?
Well, it states that the obligation to consult has to be considered in procedural obligations. So if information's been presented and that information has been evaluated by both sides, then to me, that's a statement or at least the beginning of whether or not negotiations can go forward. If someone is withholding information and then it only shows up during the negotiation, then I see that I don't see that as a part of building good faith.
Okay, well, good. So you're making an effort, due diligence, all the diligence that is due for that particular scenario based on the information that's available, whether it's secret information or known information, and you're coming to the table. Again, these are sort of really fuzzy legal terms that once you take them to court, the courts typically do define them, and they can find violations. But due diligence is a standard that's pretty common in the U.S. in terms of how much diligence is due in a particular situation. Yeah.
So with that in mind, will countries sign like confidentiality agreements or non-disclosure agreements with each other, or are they bound by this not to share?
It depends in relation to whom. So if two countries, if the U.S. and Mexico sign some kind of non-disclosure agreement as between them, why would anybody else care if there's nobody else on the watercourse? Now, if you said that Egypt and Sudan signed some kind of non-disclosure agreement, that could have implications for other riparians on that river, and then you may have a problem. So it really depends on the circumstance, and due diligence really reflects the circumstances. So due diligence on one river, due diligence in one country, it's going to be different based on the circumstances. So how you judge cooperation is really going to differ in Central Asia versus the Nile River versus the Mekong River. Did they cooperate? Well, it really depends on the circumstances, and did they make every effort? Did they have the resources to make the effort? So the U.S. would be at a higher standard for cooperation than Vietnam, for example, on the Mekong. U.S. and Mexico, you know what? Maybe the U.S. would have a higher standard as compared to Mexico in terms of due diligence and cooperation. And in fact, when you look at U.S. and Mexico activities on the Rio Grande, in the International Boundary Waters Commission, they do seem to be shouldering, at least financially, a greater burden of activities. So it seems that the U.S. is actually undertaking that due diligence, good faith effort, at least with the U.S.-Mexico. So that's one point. Let's go to, here's regular exchange of data and information. What type of data and information do you think should be required on a watercourse versus the type of information that is nice to share but doesn't have to be required?
I think anything that deals with the toxicity of the substrate that you're storing needs to be shared with your neighbors.
Oh, right.
Okay, so chemical makeup of the water and the surrounding the bed of the river or the rock formation of the aquifer.
Well, in this, the instance that we were looking at, the storage potential, that should have been well known to anyone downstream that under certain conditions, the release of that could be detrimental.
So how about that? A large dam that's being constructed, which means you're going to create a reservoir. So you have a storage potential in that reservoir. What's the volume of that storage potential? How much water could be actually stored in that reservoir? And if that dam breaks, how much water might be expected to flow downstream, right? So that kind of information. What else?
Your uses for it, you shouldn't have to disclose all of them.
You should not have to disclose all your uses. Why not?
Just because they might argue with you about the type of water the amount of water you need for this and the amount of water you need for agriculture. And they might not understand the complete inner workings of your economy and how y'all function as opposed to
okay.
neighboring economies.
So how do you go about deciding how much water you need if you won't disclose the uses?
I guess you don't need to disclose every single use.
Okay.
Just have some miscellaneous uses type of thing.
Okay. What would it depend on? The type of information that you would disclose.
It seems like what you're using it for is more substantive versus procedural. We're going to make sure that this amount of water gets to you. How we use it within the country is part of the sovereignty issue.
Okay.
So as long as we're fulfilling the procedural agreements, there shouldn't be an issue with how we use the water.
Yeah. Good. What else? What else? I mean, how else can you conceive? Let me ask you this. Procedurally, how do you implement the data sharing?
The more harm that it could produce, the more information should be shared.
Okay, should you gauge data sharing based on potential harm?
If you're trying to make a risk assessment, you would need to do that.
Okay. What about equitable and reasonable utilization? How would you implement equitable and reasonable utilization if you don't know what everybody's uses are that might be equitable, reasonable, or inequitable and unreasonable? It's a different type of risk assessment from that might result in harm versus that might result in inequity but not harm. Or, I mean, it could result in harm, but it might not.
So if we're talking about procedures, let's say there's some sort of agreement between two or more states, they could put in that agreement, we need to have some sort of report on water quality, water quantity within each of these states every so many years to sort of assess what's there. That could be saying we have so many industries on this on the stream, and they have X amount of contaminants. And that can be determined by the states, how much they want to disclose and how much they don't want to disclose. But it could include the uses of quantity and then the uses in quality. Sort of, I guess I'm thinking similar to the Texas State Water Plan, how different regions report their uses, and they could probably do that with quality and quantity.
Okay, how would you exchange this? What's the mechanism for regular exchanging?
Well, the Texas State Water Plan is in a report, so they could publish the report, or they could have a meeting or a conference where all of the officials come together and discuss these things. I guess it would depend on whatever works best for that particular group of states.
And I want to make sure you're not brushing this off as irrelevant. But what the last part about what you just said is really extremely important. The mechanism of exchange, whether it's just publishing it on the web, or sitting down at a conference, or sitting down at an official meeting, this becomes very political in terms of who goes to the meetings, at what level of authority. Are these just technocrats exchanging the information, or are these the politicians, the elected officials that are exchanging this information? The mechanics of that exchange.
What's important is,
What's that?
What's important is you got to make sure it's not a political majority, because I think that the only way the river or the water is going to be taken care of for its uses or for the people is if you have a scientific based body that is between the political sides.
And I think that's a really interesting idea, the notion that you leave the data exchange to the technical community, and they get together at these conferences or especially set up meetings, and not the politicians. We do this differently around the world. In the U.S. and Mexico, we actually have a commission, and everybody there is either I think 90% of them are technocrats. They're engineers and water managers, and they occasionally have one or two lawyers on each side. No politician. The only sort of politician is the commissioner on each side, who's appointed by the president of each country. And actually, it's required that appointee be an engineer, not a politician. So that's how we do here, U.S.-Mexico. If you're talking about other countries that are sharing data, they're doing so at the political level. And it does get complicated in terms of what information is actually getting shared between them and what is being politically coordinated. All of these are procedures in terms of how you achieve this. The actual exchange of data and information, the process, whether it's through a commission or through a conference or through putting it in the mail or publishing it up on the web, these are procedures, and you have to decide whether the countries have complied with it or not. And it could be U.S.-Mexico have to decide whether each other has complied or not. Now, there may be sub-rules between U.S. and Mexico, but the general rule is regular exchange of data information. How the details of that are implemented on the Nile versus the Mekong versus anywhere else, that's going to be very river basin specific. Look at another obligation. Okay, a couple people mentioned notice about planned measures. One of the pretty unique things about the UN Watercourses Convention, we don't have one article on planned measures. We actually have 9, and they go step by step. So Article 11 there says Watercourse states shall exchange information, consult each other on the possible effects of planned measures. So first of all, you're telling them that they have to coordinate, cooperate, and consult on planned measures. Article 12 says that you have to give them notification in advance before you begin that activity, that project that may have a transboundary impact. And then moving forward, there's a back and forth. How much time do you give them to respond? And what a response means, and what if they don't respond? And absence of reply to notification. They don't respond to your notification. What happens there? If they do respond, and they don't agree with your suggestions as to whether it will have an impact or won't have an impact, you're supposed to consult. and so on. So the UN Watercourses Convention has a pretty detailed procedures for prior notification. Why? Why so detailed? Why so many details on how you implement notification?
Without the details, how would you ever establish the governance of that watercourse?
Okay.
I mean, does the UN expect, say, a watercourse to be governed by the UN, or are they just simply applying principles that would be used for the governance of a watercourse by individual states?
Well, we do not have a UN level governance system where the UN governs any watercourse. This UN convention is a convention that articulates the international law that states are supposed to follow. So whether it's US, Mexico, or Sudan, Ethiopia, Rwanda, Burundi, and all the Nile rivers, this is what is suggested or arguably required as international law that states must follow. Remember again, what's the point of procedural obligations? We're trying not to get to the point of the substantive violations, right? We're trying not to get to the point of significant harm, violations of equitable reasonable utilization, violations of transboundary pollution prevention. So we have all these obligations for procedures on regular exchange of data and information. A couple more I'll point out, and then we'll move on.
Why, if we have so much value on the notification and these procedures, the court in the case that you have those read about pulp mills, then allowed for the continuing of the construction of that while the case was still in.
Great question.
I would think that they would stop it in good faith for both sides.
Okay. Why would a court decide that where there's a dispute between nations over construction of certain activities on a river, the pulp mills in that case, that might have transboundary impact, why would the court say, while this case is ongoing, you can go ahead and continue construction? What do you think?
Well, in this case, they said, well, there was not enough evidence that some harm will happen. Well, but then at the end, it hints that by allowing it to continue, then it gives them like a right at the end that then may be harder to take away than to stop it at that moment. So they kind of flip from one side to the other in the discussion.
Okay. So they do flip a little bit in the sense, I think you're right, that it's sort of the longer they construct, the more they construct, it creates more of a right to have that operation. But at the same time, when you go to court and one party is saying it's going to cause harm, the other party is not, it's saying, no, it's not going to cause harm, who's got the burden?
In this case, it was Argentina.
Right. And so that's the party that
and they
was...
did not meet the burden.
They were arguing, they're the party that was claiming the potential transboundary harm. And as you know, you go to court, you have what you need to have, a prima facie case, right? Before you can push the burden onto the defendant. So the plaintiff has to come forward and say, I've got a prima facie case, here's the evidence that it's likely to cause harm. Now, where's the threshold, likeliness that it's going to cause harm?
What got me is that they said that they failed to notify.
Okay.
So I thought at that point it should stop right there, and they should have given the injunction at least of stopping that.
So what is the remedy for failure to notify?
No damages, just the...
Exactly. It's a procedural violation, and it's arguably there's no substantive violation when you violate a procedure. The remedy is, well, you should have followed the procedure and now you have to. So it's a little awkward because they allowed them to continue the construction. Well, what would be the remedy? Okay, Uruguay, with this law, or Uruguay is going to say, hey, yeah, you just sued us, so now we know you know, so there's your notification. We're going to continue constructing our mills because you haven't presented a prima facie case of potential harm. And that would be, and this is the problem that we have with international law for transboundary waters. The substantive obligations are actionable after the fact. It's very problematic. No significant harm, equitable reasonable utilization, pollution prevention. They're really actionable after the fact.
Yeah, in my opinion, an injunction should have been from preventing construction until they did more studies on the environmental impact.
So, good. Say that again.
That, in my opinion, an injunction should have happened.
Injunction?
Until at least some more environmental impact assessments should have been done to see how much was going to be the harm.
So the court should have imposed an injunction based on what law?
I know.
We don't have international law that mandates something like this. We don't have that based on customary international law. So no state has ever agreed to an injunction, that it will self-accept an injunction against itself pending development of more information. And on the flip side, we've never had any UN agency or international organization argue that there should be an international law that would give authority to a court like this, international tribunal, the power of injunction to stop a country's construction until we have more evidence of whether the activity will or will not cause harm.
Or mining or anything.
Absolutely. It could be anything related to the water that might have a transboundary impact. Yeah. And why don't we have this? Why have states not agreed to give a court authority to enjoin them, to enjoin their action?
The economic aspect of it.
Sovereignty.
I would say the sovereignty. What country would allow an external body? Come on, this is the U.S. What can you imagine any U.S. president, anybody in the U.S., be willing to give authority to, whether it's a UN agency, International Court of Justice, some tribunal, to give authority to tell the U.S., hey, you guys must stop this activity right now until we have better sense of what potential impact it might have?
Not even Obama would do that.
Not even Obama would do that.
Seeing people are paying attention.
But it's in the best interest of everybody. I don't know.
Okay, it's in the best interest of what?
Everybody.
Everybody. But do we rule this globe as a globe? I'm going to give you my wacky theory on how when we'll actually start operating as a globe. It's my Star Wars theory. Until we see aliens out there, when we have a new us and them, right?
Not gonna be us.
Like Independence Day, exactly. You see the movie Independence Day? It's exactly the situation. We're going to be us and them here on this earth. And we are not willing to give up, and it goes back to sovereignty. We're not willing to give up our sovereignty to another country or to some international body that will have the power over us to tell us what to do or not to do. And this is exactly why, if you look at the statute of the International Court of Justice, it says that the states who go to the ICJ must do so voluntarily. They must agree to go to the court. They must agree to the jurisdiction of the court. And the U.S. has agreed to it ad hoc, meaning on a case-by-case basis. There are some cases that U.S. have said, no, we're not going to go to the court. And other cases said, sure, we'll go to the court, we'll accept the decision. But this is how we've established international law. We do not have an international police force or international government, despite what many Americans believe. So, no Black Hawk helicopters.
It's very plainly stated, though, that cooperation is absolutely the basic principle, and then it stops by saying not only is it a basic principle, it's a legal duty.
Good. And what's the consequence for violating that legal duty? What's the remedy? There's no damages on a violation of a procedural obligation. The remedy is you must comply. But the problem is we don't have a police force to enforce compliance. Our enforcement mechanism is economic sanctions, peer pressure amongst the countries, and that's really about it. And occasionally we do have some countries, that act like 900-pound gorillas, and they do it by intimidation.
Can you give us some background on what exactly like the UN armed forces do? Was that
UN armed forces?
NATO.
Okay. UN armed forces, when they go into a region, they're going into that region either by a UN Security Council resolution, which is not common, or by agreement of the state in which they're going into. So you can have the blue helmets in the Golan Heights, but that's because Israel has accepted them and said, yes, you can go in there, and Syria has accepted them, and they can go stand on the border and monitor. And they don't do much more than monitor.
They're limited.
Now, some of the UN Blue Helmets have been authorized. Each mission is different. Some of them are authorized to do a little more, like protect citizens. And there's a few African regions where they've actually been authorized, and they've taken some limited force to protect citizens. But it's very limited. Look what happened in the Balkans, former Yugoslavia, and the UN forces didn't do hardly anything to prevent some of the massacres there. But that's because they weren't authorized, and international law didn't mandate or require them to do so. The Blue Helmets, they're not much more than, I hate to be so pejorative, so negative, but mall cops. Security guards in some cases. They do help. They do help calm the situation down, but they don't have much authority. NATO forces, that's a little bit different, because now we're talking about a security force as between the NATO members. And if the NATO member countries authorized, then they might go into a place like Afghanistan, because they claim, one of the NATO members says, hey, our interests have been harmed, and they were tying it to 9/11. That's why NATO went into Afghanistan. NATO forces went into Libya. Again, NATO countries, European countries, were very concerned about the impact that what was going on in Libya at the time. And so they authorized forces to go in there to try to restore the peace. Beyond that, it takes a Security Council resolution under, I think it's Chapter 7, to say countries can send forces like they did in Iraq. Remember the coalition? That was Chapter 7 of the UN Charter. But we're talking serious humanitarian issues, war, countries fighting each other, allegations that Al-Qaeda in Afghanistan was responsible for 9/11, World Trade Center, a watercourse dispute. I've never seen UN Blue Helmets or NATO members get involved. Could it? Maybe at some point, but very unlikely. Very unlikely. But I want to bring up the article that I had you read about the Pulp Mills case. What was the big procedural obligation that the court came up with that said that there's this procedural obligation that we have to implement
touch bases on all of them, but let me see.
It did talk about many of them, but there's one in particular.
The cooperation, they said they needed to share more information. They said that Uruguay failed to notify, but I don't know exactly.
But there's something, a very unique procedural obligation, something that they were supposed to do or should have done or didn't do completely. And it's actually in the title of that article.
Oh, there. EIA, there.
Environmental impact assessment. What is an environmental impact assessment?
Determine what the new project will do to the environment and also the economy around it.
Okay, so an assessment of what the project might do to the environment.
Future, yeah.
Okay. There's got to be one of you guys in College Station or Galveston. I'm sure somebody there has worked on an EIA, right?
Tell them, Robbie.
So, I mean, give us a sort of an explanation. What does it entail, and how do you put one together?
Haven't you ever done that? Are we on? You? Yeah, we're on. Speak.
Okay.
I mean, there's a lot of.
So, is somebody else talking?
Let's start with Galveston.
There's a lot of components. Some of them being you need to assess the state of every organism and the potential harm for every organism in the area that may be affected. So it can be gigantic. So
okay.
A lot of times it can be used to justify stopping anything because it's easy to kind of see some type of harm. So when you get into touching an organism that's under any kind of threat, it's often a way to shut down production of something. But I recall the article talking about how it's become so widely accepted amongst, I guess, the industrialized world that it's kind of become assumed to be a part of this kind of international collaboration. So even though the charter does not mention things specifically, it's become so useful and so commonplace in many nations that it's sort of assumed now that it's going to be a part of notifications and stuff like that.
Okay, good. There was a comment in College Station.
I would just add that it looks at a potential project and the effect on the environment and social justice issues regarding a particular project or action. So.
Right. So good. So now let's take this one more step. It's not just that you have to you have to conduct an environmental impact assessment. It has to be a transboundary environmental impact assessment. So the fact that they built the pulp mills in Uruguay, they weren't going to be required to create an impact assessment on the Uruguay environment. The court was saying you need to conduct this transboundary environmental impact assessment. So that's one point I just want to throw out. But I want to go back to the gentleman in Galveston, and I want to ask, when you were conducting, or when you've seen these impact assessments being conducted, under what authority did they come down? What's the law that they were under?
NEPA.
NEPA. Does anybody know what NEPA is? National Environmental Policy Act. What's the outcome? And this is the statute in the federal government that we have here in the United States that mandates environmental impact assessments whenever you have what they call major federal action, or when so basically when a federal agency, government entity is involved in any kind of activity that may have some kind of impact on the environment. And activity here is defined pretty loosely in terms of whether they're leading it or just funding it or just giving a permit or anything to that effect. I said a good number of states have their own state version of this. Here in Texas, we actually don't have an impact assessment law. And so the argument, as you were saying, most of the industrialized world does seem to have in their domestic law impact assessments, and now it seems to be that there's some kind of international custom that we have this impact assessment. Good. Now, next question. Whether under NEPA or any other statute, to what extent is the outcome of that impact assessment determinative? The reason I'm asking is because when you were explaining the content of an impact assessment, you said something, if I remember, many people use these to prevent projects from taking place. Is that, I think you said something along those lines.
Yeah, because there can be, well, it can be highly objective how you want to take account for everything. So
Okay.
there's only so much you can actually measure. So many organisms or,
Right.
plants and so forth you can really do. So a lot of times it's, certain organisms are used as monitoring species. But you can imagine that these things can be kind of toyed with a little bit. So
Okay.
when someone wants something to happen or not happen, that might go into what is monitored.
Right.
I know
But now the question is, to what extent is the outcome of this study determinative?
I know
Has
they.
anybody studied NEPA?
I know they look at two things. It could be more, but I know they look at two things. Is one, they'll look at the endangered species or threatened species in the area, as well as how important is that habitat to the ecosystem around it. I know those are two, like for example, like a deforestation project or a logging, or I guess it would be a logging project that they would actually, by the impact statement or assessment, they would derive that it's actually too much of an ecosystem imbalance that it would cause, and then that's why they would shut it down. Or if there's an invasive species in a nearby stream, or an endangered species, threatened species in a nearby stream. Like it really matters about the containment of the situation. How big do they really want to put the parameters on a project?
Right. Now let me. I want to pull out the endangered species out of this because that comes under the Endangered Species Act, and that statute is very determinative. Because if you have a potential impact on an endangered species, the statute explicitly says you can't do that action. You can't. So let's take out endangered species out of this equation and just look at species in general that are not endangered, the environment that's not, just environment in general. If you look at NEPA, there's nothing in NEPA that says if you have a horrible negative outcome result from an impact assessment study, there's nothing in there that says you must stop this activity. All NEPA says is you must conduct an impact assessment. So that's when I asked, is it determinative? The answer is no. It's another piece of information for the purpose of making the final decision of whether to continue or not continue. Now, for the Endangered Species Act, yes, you do have, that's very determinative, because if you have a finding that could affect an endangered species, the Endangered Species Act says specifically you can't take that action. But under the NEPA statute, Environmental Impact Assessment, all it says is if you have a potential environmental impact, you must conduct an impact assessment and present that information, public disclosure. What the court in the Pope Mills case was basically saying exactly that. Procedural obligation to conduct a transboundary environmental impact assessment, and the violation for not having conducted it is you got to conduct it.
Yeah, like if you start a project, really it's just beating around the bush. You got to conduct it eventually. Like, if someone raises a concern about it, you're gonna waste time and money on other resources that you could just be streamlining your project. So really, it's just like you got to find adequate, or it's at. Why did you want me to say adequate? I'm being summoned to tell somebody else's story because they don't want to be on the monitor, but they'll be disclosed. But basically, we wanted to ask, what do other countries do to have this impact assessment?
Okay, I'm getting some other conversation in the background. I didn't hear the full question. Could you repeat the question?
I think he was asking, what do other countries do to get to that assessment?
To get to the assessment.
I think so.
I think it's the same procedure that we have in the U.S. in terms of if there's a finding of a potential impact, then there needs to be an assessment conducted. Again, in all of these countries, certainly all of the European countries, in the U.S., Canada, all these countries that have an environmental impact assessment statute, it's not determinative, meaning it does not decree an outcome. The only thing that's decreed is that you have to conduct an assessment and do it transparently and make it public, and then let the political process, the politicians or the agencies, take that information and then decide based on that additional information. Because, for example, you may have an absolutely critical need in the country that's going to cause horrible environmental impact, but you still have that need. Let's say we need water for drinking because we have a massive drought, but if we reroute all the rivers, we're going to kill off all the fish. I honestly think that in that condition, in that situation, drinking for people is going to win out over drinking or water for fish. But you have to show that the need outweighs the potential harm. The statutes typically say you need to conduct an environmental impact assessment. What that means in each country has its own criteria of what an assessment is and how much information, the type of information, the quality of the information, the scientific justifications and background. That becomes a country by country bit of information. The general rule is procedurally environmental impact assessment, and now according to the International Court of Justice, as between countries, there is an obligation to conduct a transboundary environmental impact assessment. What will that activity, what are the potential impacts across the border? So I don't know if that answers the questions you guys had in College Station.
I have another one. So usually in the U.S., if you did an EIS, an agency would issue a FONSI or a finding of no significant impact. So what you're saying is on the international stage, you don't have to have that. A country would do an assessment, but you don't need a finding of no significant impact.
Waste of money.
Well, the FONSI, that's an American component of our environmental impact assessment system. They have something similar in Europe, which is findings, but according to the court, to International Court of Justice, they did not interpret that as having reached the status of international law. They're coming up with general rules. They're not coming up with the specific components of how you implement that. They're just saying, hey, country A, you have to have a transboundary EIA, and do it. So that's how I would respond to that question. Anything else? So if you think about it, all these procedural obligations, notification, data sharing, environmental impact assessments, what else was there? Cooperation. These are all designed to prevent or mitigate against potential harm. Again, they're different from substantive obligations in terms of the remedy. Remedy for substantive obligation is usually some kind of damages. You've got to pay for the damage that you've caused, whereas a remedy for a procedural violation of a procedural obligation is typically compliance. Again, we don't have an international police force or international governance structure that enforces these obligations. So these obligations get enforced through peer pressure, economic sanctions, and occasionally, if you have a very powerful country in a particular river basin, they might try to encourage parties to cooperate in a certain way. So, for example, in Europe, Germany and France seem to be the stronger countries on the Danube, on the Rhine, and they do seem to dominate the activities on those particular river basins. And they have had very good success in terms of getting countries to conduct environmental impact assessments, to cooperate, share data, to the point where it's now reached the level of the European Union. And we now have what's called the Water Framework Directive that actually requires all these procedural activities on the European level. In the Mekong, your hegemonic power is China, and they have taken a different approach on that particular river basin. Nile River, we used to have a hegemonic power of Egypt, and now it seems like it's a bit in flux. We're not sure if we have one power that is really the superpower of that river basin. Now it seems like we have a bunch of countries that are vying for position on the Nile, and nobody is any more powerful than another. Or there might be 2 or 3 countries, 4 countries that have some power or more power than others, but there isn't one hegemonic power in that river basin. On the Jordan River, Israel seems to be the dominant hegemonic power, and considering water information is a security matter, so you don't see much cooperation. You have seen cooperation and data sharing between Israel and Jordan, but that's because they actually have an agreement, a treaty that they entered into in 1994 that seems to address those issues, but certainly not with the Palestinians or the Syrians or the Lebanese. So we have different examples around the world in terms of how these procedures are implemented. Generally, the Watercourses Convention identifies what those general rules are and what states are supposed to abide by. Other types of procedural other types of principles that you see in the Watercourse Convention. So we have the substantive, we have the procedural, and then if you go through the convention, and I hope you do go through it, and I would expect you to go through it for our next big exercise I'll tell you about in a minute, you're going to find other types of provisions that you should consider, such as sharing expenses, whether it's on production of data or construction of projects, or if you decide to have a commission, who pays for the commission. Creation and duties of a river commission, if you have a commission. Dispute resolution mechanism. There's a whole series of dispute resolution mechanisms attached to the Watercourses Convention. And they're pretty generic. If you go to the Indus River Treaty, Pakistan and India, they have a very unique system of dispute resolution mechanisms that's very specific to that river, and they were implemented a few years ago on the Kissinganga agreement, or the dispute scenario that went to the arbitration. And there's actually another case a few years before that they implemented those provisions. Again, a little bit different than what you find in terms of the procedures under the Watercourses Convention, but the notion is you do have some kind of dispute resolution mechanism. Monitoring. Monitoring is a procedure that you are now starting to see coming up as a corollary to data sharing. So not only is there an obligation to share and exchange data, which sounds like a one-time event. Now we have potentially an international obligation for monitoring, meaning we're going to do this on an ongoing basis. We're going to generate data continuously, meaning we're going to monitor the river at different points, different characteristics, water flow, water temperature, water quality, climate change implications, water uses, environmental needs, and so on. And then continue to have the data sharing obligation going on a continuous basis. So these are just some of the procedures that you all should be paying attention to. Why? Because our next big collaborative event is going to come up. I think it's the 16th if you look at the schedule. We're going to have a negotiation session. I'm going to give you a little bit of background information on it right now. I'm going to send out the hypothetical and the instructions in the next couple of days. I'm still trying to finalize it. What's going to be interesting this time is that we have these 3 campuses. I've worked with 2 campuses. I haven't done 3 campuses now. But I don't want to do them versus us in the sense of Galveston versus College Station versus Fort Worth. I think that it would be unfair for the law students here not to have some of the technical and scientific knowledge that the folks at the other campuses have about water resources, and vice versa. You know, the law students have some knowledge about laws and regulations and developing laws and so on, maybe negotiations that maybe some other students have not had. So I'm going to really complicate this.
Draft?
What's that?
You take a draft?
A draft? No, I'm going to assign. I'm going to create teams here that cut across all the campuses. What you're going to have to do as a team, you'll have about 2 weeks to prepare by email, Skype, Hangouts, WhatsApp, whatever technology you want to use. You'll have to coordinate just like you did on the case studies.
Instagram?
What's that?
We use Instagram.
Instagram, whatever you want to use. You can use all that to prepare. When we actually have the negotiation, this is the technical part. I'm still finalizing how we're going to do this, but you'll be on Instagram, or I would suggest that's too public, but maybe WhatsApp or text messages, talking to your teammates at the 3 campuses, designating somebody to speak about a particular issue in a negotiation. We're going to have, I believe, 4 countries on this watercourse, and we're going to have a real mess in terms of issues. And your obligations, your part of your tasks will be to sort out your own country issues and prioritize them. You'll have some exclusive instructions. Each country will have a separate set of instructions. And you'll have to strategize what you're going to do when you come to the table. And the challenge is going to be your Minister of Water may be visiting at the other country. And we're going to have these 3 locations where we're visiting. Okay? So you're going to have to coordinate this. And I think this will be fun. I'm hoping it'll be fun. But you're going to write a treaty, or at least create the framework for a treaty on this watercourse between the 4 countries.
Let me
and you're
ask
going to be
a
split
question.
up. Yeah.
Question. So you said that there will be people who will speak on specific things. Will they be like an expert witness, or they would just be part of the negotiating team, or all of the above?
Negotiating team. I will, the way I'm developing it in my mind, I'm still finalizing it on paper. There will be a legal advisor or 2. There will be whether we call them water experts or minister for water, more likely minister for water, and possibly another minister that deals with another water issues like hydroelectric or irrigation or something else. And you may not have the same ministers in the same countries, because one country may be more interested in irrigation, another may be more interested in hydroelectric or industrial. So there will be 4 countries. There will be either 5 or 6 students on each team because we've got 22 students total. So, and 4 countries is really pushing the envelope on a negotiation like this. It's usually better to have 2 or 3. 4 is my maximum. I've tried it with 5, and it's too complicated.
So the water ministers, those will be like political folks, so they won't have to know anything other than how to wheel and deal around the negotiating thing.
Hopefully, like we do in the U.S., the person we assign to be the commissioner or the what's the title? The International Boundary Water Commission, the commissioner. They have to be engineers. So I will probably create countries where the water minister has to be a water engineer. So this is how we're developing it, or I'm developing this hypothetical. Your goal will be to negotiate a treaty based on your sets of priorities, your sets of needs, the secret instructions that I'm going to give each of the countries in terms of what some of these priorities are, and you're going to have to prepare and strategize in advance, knowing as much international law as we've gone over, knowing as much or as little negotiation theory as we've not gone over. I'm going to leave that to all of you. But the objective here is really to recognize what international law we do have, the limitations of international law that we do have and don't have, the politics of water, and this will be a political scenario of upstream, downstream, midstream, left bank, right bank conditions, and hydrologic facts. So water information will be important, but so will political information, and so will legal information. So
feelings going to get hurt?
Feelings going to get hurt. Hopefully we will all be civil about this.
Negotiation for nothing.
Yes. I will send out this information in the next couple of days, and I will send the general instructions to everybody, and then I will send the country instructions to each individual group, team. If you have any questions, please email me. If you have any comments or concerns about it, please let me know. Other than that, any questions here today?
Nothing from Galveston.
All right. I'm glad Galveston is still on board, and we haven't kicked you off yet, or the system hasn't kicked you off.
No. You put the fear of God in their hearts.
All right, we worked it all out. Good. All right, if there's nothing else, we'll see you all next week.
Can we trade group numbers?
All right, thanks, guys.
Oh, wait.
No, I meant like.